Okay, aloha mai kako and good morning. This is the July 14th, 2021 Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom webinar platform. We're doing this, of course, to comply with the state and county official operational directives during the still ongoing COVID-19 pandemic. Members of the public are able to view the meeting via the Zoom webinar platform. For all meeting participants, I'd like to stress the importance of speaking slowly, clearly, and directly into your microphone. This is especially important because we're also employing a new technology to transcribe the audio recording of these proceedings. So before speaking, please state your name and identify yourself for the record. Please also be aware, all meeting participants, and there is already a notice that went out, that this is being recorded on the digital record of the Zoom meeting. Your continued participation is your implied consent to be part of the public record of this event. And if you do not wish to be part of the public record, you should exit this meeting now. This technology, as we all know, allows the parties and each participating commissioner individual remote access to the meeting proceedings via our own individual digital devices. So please also note, due to matters entirely outside of our own control, from time to time, occasional disruptions to connectivity may occur. If this happens, please let us know and please be patient as we try to restore signals. For any members of the public who wish to testify on any matter to which public testimony is being accepted, if you are accessing the meeting by smartphone or desktop software, you can use the raise your hand function, or if by telephone, hitting the key sequence *9. You also need to use the key sequence *6 to mute and unmute. Depending on the length of our proceedings today, we will be taking breaks approximately 10 minutes every hour. My name is Jonathan Lee K.K. Scheuer, and I have the distinct pleasure of serving as the Land Use Commission Chair. Along with me, Commissioner at Axon, Gary Okuda, Arnold Wong, and our small but powerful staff, our LUC Executive Officer, Daniel Oradenker, our Chief Planner, Scott Derrickson, our Chief Clerk, Riley Hakoda, our Program Specialist, Natasha Canones, along with our Deputy Attorney General, Dan Morris, are all on the island of Oahu. Commissioner Dan Giovanni is on Kauai, and Commissioner Nancy Cabral is on Hawaii Island. Today, we have excused absences from Commissioner Don Chang of Oahu and Commissioner Lee Ohigashi of Maui. We currently have 8 seated commissioners of a possible 9. Our first order of business is adoption of the 2 sets of minutes, June 9th and 10th and June 22nd. Mr. Hakoda or Mr. Derrickson, has there been any public written testimony submitted on this matter?
Mr. Chair, this is Riley. No written testimony on the minutes.
Okay. Are there any members of the public attending this through the attendee function of this webinar platform who wish to testify on the adoption of the minutes from these 2 meetings? If so, raise your hand. Seeing none, commissioners, are there any comments or questions on any of either of the 2 sets of minutes? Does anybody need to recuse from one set but not the other? If not, I'll accept a single motion to adopt both. Commissioner Cabral.
I'll move to adopt those.
Okay, is there a second? Commissioner Wong seconds the motion. Any discussion? Commissioner Okuda?
No, Chair. I was just unmuting myself for the vote. Sorry.
Okay.
This is Gary Okuda.
Yeah. Dan, would you do a roll call vote?
Thank you, Mr. Chair. Motion is to adopt the minutes for both agendas. Commissioner Cabral.
Yes.
Commissioner Wong.
Aye.
Commissioner Axon.
Aye.
Commissioner Giovanni.
Aye.
Commissioner Okuda.
Yes.
Chair Schreier.
Aye.
Commissioners Ohigashi and Chang are excused. Motion is adopted.
Okay, thank you very much. Our next meeting agenda item is the tentative meeting schedule. Mr. Orodenko.
Thank you, Mr. Chair. The hearings for the end of July have been continued to a later date. We will be meeting on August 25th for a status report on Kula Ranch. I have to note for the commissioners that until at least January 1, we will be holding meetings under the old rules, which would require either in-person or notification of where the commissioners will be. if they're-
Dan, I don't know if you can go closer to your microphone, but the audio is not picking up particularly well.
Thank you, Mr. Chair. I have to caution for the commissioners that beginning in August, we will go back to the old rules with regard to held at least until January 1 when the legislation comes into effect. That means that meetings will be held in person on the island in which the land is located. Any virtual attendees will have to be located at a place where the public can also attend, and notification of those locations given to the public. So August 25th, we will be on Maui for the Kula Ranch status report. On September, excuse me. On September 8th, we will travel to the Big Island for the church matter. On September 9th, we will be on Oahu for the Maui solar matter. On September 22nd, we will travel again to the Big Island for the Honiopu Hideaway DR. On the 23rd, we will be on Maui for Waikapu properties matter. October, we are hoping that we can take up the IAL matter on Oahu on October 13th and 14th. That's pending the completion of the review by the Attorney General. And November currently is open. On December 8th, we have the Windward Airport Hotel matter on Maui, and that takes us through the end of the year.
Okay, thank you very much. Commissioners, are there questions for
What was the
Dan?
date in October? This is Dan Giovanni.
October 13th and October 14th.
Thank you.
Thank you.
Commissioners, other questions? Okay, seeing none. Our next agenda item is docket number A11790, Kula Ridge LLC Maui, to consider an order to show cause for docket number A11790, in which the commission granted the redesignation of approximately 34.516 acres of land from the agricultural district to the urban district, and approximately 16.509 acres of land from the agricultural district to the rural district at Kula, Maui, Hawaii, for a mix of residential, park, and open space uses. Will the parties please identify yourselves for the record? Beginning with the petitioner.
Good morning, Chair and members of the commission. My name is Jeff Uyoka, representing the Raymond M. Vontensky Marital Trust. Thank you.
County.
Good morning, Chair and Commission members. Michael Hopper, Deputy Corporation Counsel on behalf of the Maui County Department of Planning. With me are Deputy Planning Director Jordan Hart and Planner Tara Furukawa.
Jordan looks very different, Michael.
Jordan, Deputy Director Jordan Hart.
I think you have Michelle McLean with you.
Oh, it's listed as Jordan Hart here.
But I'm looking and I'm pretty sure it's Michelle McLean.
Here as well.
I can hear Jordan laughing in his office.
I'm sorry, he was here for the last item. She's here as well. So thank you, Chair.
No problem. Office of Planning, and maybe if your clients would make themselves visible, we won't have any confusion.
Good morning, Chair, Commissioners. Allison Cato, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here are Rodney Funakoshi and Lorraine Maki from the Office of Planning and Sustainable Development.
Thank you. Now let me update the record now that we've done correct appearances. Rodney, you can stay visible. On April 14th, 2021, the Commission met via Zoom virtual conference technology to hear a status report on this matter. On June 3rd, 2021, the Commission issued and mailed its order to show cause, Exhibit A, petition area map, certificate of service and notice of hearing to all the parties, as well as a letter to the petitioner. On June 18th, the Commission received the Office of Planning's position statement of no position. On June 24th, the Commission received the County of Maui's position statement that it was not opposed to the reversion of the petition area back to the agricultural district from the urban and rural land use designations. On July 2nd, the Commission mailed our meeting agenda for today's meeting to the parties in this docket and to our statewide and county mailing lists. On July 8th, the petitioner filed a stipulation of the parties on the LUC's order to show cause dated June 3rd. On July 9th, the Commission received public written testimony on this matter from Dana Naoni Hall. Also on July 9th, the Office of Planning and Sustainable Development filed an amended statement of position to the order to show cause, a certificate of service, an amended list of exhibits numbered Exhibit 1A, 1B, 2, and 3. Just to go over our procedures, I will first recognize any other written testimony received on this docket. I will then call for any individuals who wish to provide oral testimony on this docket. After you raise your hand using the raise your hand function, I will bring you in, swear you in, ask you to state your name and address for the record, and then give you the opportunity to testify. Following your testimony, you will need to remain available for questions from the parties in this docket and the commissioners. Following the closure of public testimony, if any, I will allow the petitioner to present their case in the order to show cause. Should it choose to do so, the petitioner can be allowed to introduce evidence as to why the petition area should not be reverted to the original classification. After the petitioner's presentation, we'll receive questions and comments from the commissioners. I will then do the same procedures for the County of Maui and the Office of Planning. Petitioner will be allowed to offer any closing arguments that they might make. And then following that, after any questions from the commissioners to any of the parties, the commission will conduct formal deliberations. That probably took longer to say than the hearing might take today, but we'll see. I will note, as I did before, from time to time, I will reserve the right to take breaks. Are there any questions with our procedures today, starting with the petitioner?
No questions, Chair. Thank you.
Thank
Jeff
you.
Uyoka.
Thank you. Mr. Hopper,
No, Chair, thank you.
Ms. Cato.
No questions, thank you.
Okay. I noted for the record that we received testimony in written form from Dana Naoni Hall on July 9th, 2021. Mr. Hakoda, has there been any further written testimony received on this matter?
No, Chair.
Okay, the testimony of Ms. Hall, I believe, has been posted to our website as well and made available to the parties. Are there any members of the public who wish to testify on this matter? If so, no one's calling in by phone, so use the raise your hand function in your Zoom software. Does anybody wish to testify on this matter? Seeing none, we will have no public testimony on this matter. We can now hear from the petitioner.
Jeff Uyoka. Thank you, Chair. I believe Mr. Welch presented thoroughly at the earlier meeting, so I'll be available for questions if you have any, you or the members have any questions. Thank you.
Okay, thank you. Are there any questions for the petitioner from the commissioners? Commissioner Okuda.
This is Gary Okuda. Thank you, Mr. Chair. Mr. Uyoka, let me tell you one of the concerns I have, although I'm not sure if the commission has a remedy. It is true that the decision and order required a certain amount of affordable housing units to be built as a condition of the boundary redesignation. Isn't that correct?
That is my understanding, or Jeff Uyoka, that is my understanding, Commissioner Okuda.
And I understand that it wasn't your client that may have made, certain representations, but this requirement, as we lawyers say, runs with the land and is an encumbrance on the title, unless the Land Use Commission today decides otherwise. Is that correct?
Jeff Uyoka, that is my understanding, is a condition that is on title for this parcel or the parcels.
Okay. And this is Gary Okuda again. Given the fact that in the DW Ina Lea case, and since we don't have a court reporter, DW is capital D, capital W, Ina is AINA, Lea is LEA, development is abbreviated DEV, period. There was an admonition at page 709 of volume 339 Pacific 3rd and 187, that's the page of 134 Hawaii Reports, where the Supreme Court, quoting the underlying legislative history, raised a red flag about the fact that land that gets a boundary redesignation gets value just because of the fact that the boundary or the zoning has been changed. Do you agree with that?
Jeff Uyoka, I'm not overly familiar with that case, but it seems like you are reading from it, so I can't disagree.
Hey, this is Gary Okuda. So during the time from when the landowner received the boundary designation up until today, have there been any parties that, for the lack of a better term, took equity out of the property? In other words, made money or made a profit because there was this change in a boundary designation from the prior designation into urban. In other words, did someone make money off of this property because of the fact that you had this boundary redesignation?
Jeff Uyoka, as far as I know, Member Okuda, no, there has been no gain by anyone. I think it's been a lot of expenses, but I don't think there's been any gain by anyone. Thank you.
Okay, is there anything in the record that indicates that no one made money off of this property during the interim?
Jeff Uyoka, Member Okuda, not that I am aware of.
Okay. This is Gary Okuda. This is the concern I have, and maybe you can tell me how, if it can be addressed. The concern I have is that we receive representations by petitioners that certain things will be done, such as affordable housing, and these promises are not kept. Besides a reversion, do you see anything any government agency can do? And I'm not limiting government agencies simply to the Land Use Commission, but do you see any thing that other government agencies can do to require compliance with these representations so that promises, for example, of affordable housing are not just simply empty promises to the community?
Jeff Uyoka, Member Okuda, that's a interesting concept. For years, I actually worked for the county, and I used to advise the Department of Housing and Human Concerns, so I am familiar with affordable housing. And the position I often had for the, I guess, the incentive for a developer to follow through on everything was typically when they do these projects, there's a profit at the end of it. So it behooves them to fulfill all of their requirements. And for a lot of these, you don't get the market units without doing the affordable units. So that would be the requirement that would need to be met in order to, typically the market units are where you make the money. So that was always my understanding and feel on why someone would go through the process of, changing zoning for the county level or a 201H fast track affordable housing project and the district boundary amendment on the state level is the idea that they'd be profiting somehow from the development. So at the end of the day, that was always my understanding of what would motivate individuals to follow through on the requirements and get the project going. Thank you.
Yeah, this is Gary Okuda. My final question to you, Mr. Uyoka, and I might pose similar questions to the other parties, is I do agree that economic carrots are the best way to have efficiency in the economy. But do you think that sometimes there's a necessity for a legal stick? For example, bringing an action for what we call in the law specific performance. In other words, where a request is made to the court to order a owner of a property which is subject to this type of encumbrance to carry out the representations that were made. Is there anything in the law that you know that prohibits the use of a specific performance action to require a developer to, or a landowner who has property which is subject to a requirement to provide affordable housing to be specifically required to perform that promise or encumbrance?
This is Jeff Uyoka. Thank you, Commissioner Okuda. I'll leave that more to your Mr. Morris or Ms. Kato to give you specifics on what you guys can do. I am not aware of a prohibition in the law. However, I will say if specific performance is something that you could be subjected to as a developer, I'd be very hesitant to advise my clients to move forward on certain matters. It'd have a chilling effect almost. You would probably get less development in the state because developers would be afraid that if circumstances change, a pandemic hits, who knows, things in the world change. I don't know what else could happen. The pandemic kind of blew my mind, so I don't know what else could happen anymore. But if circumstances change and you can't develop for whatever reason, and you'll go bankrupt or lose a lot of money, and you have this onus on you that the state can force you to perform, that's a huge risk that you'd take. And I understand the importance of getting a district boundary amendment from this body, but that's a very large risk. Thank you.
This is Gary Okuda. Thank you very much, Mr. Uyoka. Thank you, Chair. No further questions.
Thank you, Commissioner Okuda. Commissioners, further questions for Mr. Uyoka at this time? Seeing none. Mr. Hopper.
Thank you, Chair and members of the Commission. The County of Maui, along with Office of Planning and the current landowner, have entered. Oh, I'm sorry. I have no questions for the.
No. I was asking you to present your case.
Okay, just wanted to be clear, because there's been no witnesses in this case. The County of Maui has entered into a stipulation with both the current landowner and Office of Planning, similar to the Halemua docket, agreeing to not oppose the reversion of this property to agriculture. The department has filed a statement of position stating no opposition to the reversion, given that there are a number of conditions that have not been complied with. And probably most significantly, the current landowner has stated that they don't have the ability or the capability to complete the project as represented. Therefore, the County of Maui does not oppose reversion and in fact has signed a stipulation, again, similar to Halemua, because we think the circumstances are similar, to allow for the reversion of the property without the necessity of going through the full hearing. But I am available for questions. Planning Director Michelle McLean's here as well and could answer questions if there's something that needs to be addressed. But we have filed both a statement of position as well as a stipulation in this docket. And so I think our position's been made clear. Thank you.
Thank you very much, Mr. Hopper. Are there questions for the County of Maui from the commissioners? Commissioner Axon.
Thank you, Mr. Chair, and good morning, Mr. Hopper. This is in line with Commissioner Okura's questioning of the petitioner. As you know, Land Use Commission, the only option we have on this, if the conditions are not being followed, is to revert the property to the original designation, while the county has all the enforcement power to make the petitioner comply with the conditions. What have you done? What have the county done to make the petitioner comply to these conditions? And also, again, in line with Commissioner Okura's questioning, is there any way or any way that the county can force the petitioner to comply with those conditions?
Thank you, Chair. To date, I think the county, up until, I think the first indication that the property would not be in substantial compliance was, there was a letter earlier, I believe it was earlier this year, it may have been in 2020, where the new landowner had stated that they did not have the capability of going forward with the project, and then the order to show cause ensued. I think because there had not been substantial commencement and reversion was still an option, that was the preferred method of enforcement. The other options, and I did look at this a bit because I know Commissioner Okuda had asked about it in HRS 205-13, there can be monetary fines issued for non-compliance. However, that does require essentially a 60-day notification in advance of those fines being issued and essentially allowing the landowner an opportunity to comply. So it would have been, I think, in this case, difficult to find because I think the landowner has said, we're going forward with, we would request reversion because they admitted they did not have the capability to go forward. And so since they did not oppose reversion, and that's one of the methods, and it's in fact in your decision in order that reversion is a potential method of enforcement, I think that route was considered an available one and a preferred one. As far as a legal action, I do think if a landowner is violating the conditions, that there could be a potential for injunctive relief to stop that violation from going on. But an action for specific performance, I don't want to foreclose any possibilities of legal action in the future. Just to note that it would maybe be difficult to have a court require somebody to build a project in a certain way. I don't know if there's any precedent for that in any area of the country. Maybe there is, but not that I'm aware of, where a court has ordered the completion of a development. I mean, I think you can say complete the development this way, or else there can be fines, or the development will be halted until it's in compliance. That's another method of compliance. I suppose the county could withhold future permits for a project if it was no longer in compliance. Maybe they had started to build, you have substantial commencement, and in order to show cause wouldn't be a potential method, but you could still state that the project couldn't go forward anymore. Now, we're getting a little bit into the theoretical here. I do think in this particular docket, there has not been substantial commencement, and reversion is a method of enforcement that the legislature as well as the commission have both outlined as a potential enforcement method. And I think that's where the county would think the appropriate enforcement would take place. But there are some other options for enforcement. Fines, most likely injunctive relief or withholding future development approvals until there is compliance, I think are all potential options that a county could have in enforcement in addition to reversion.
This is Edmund Axon again. I guess I'm not gonna ask you what course of action the county in mind, but if the commission decided to revert the property to its original designation, is that course of action still applicable that you were thinking,
Well,
or the county thinking?
I think if it's reverted to agriculture, the decision and order would most likely be released, right? I mean, the land wouldn't be urban anymore. So the conditions that were essentially mitigating conditions in exchange for the urban designation I would think, and the landowner can correct me if I'm wrong, but they would be seeking to have the conditions released because the land would be agriculture rather than urban.
So in short, if we make a decision to revert, there's nothing the county can do or any agency can do.
Well, they wouldn't be in violation of anything, I think. They'd be agriculture. So I think that's the idea of the reversion, is that you go back before the commission took its action, and they would no longer be urban, therefore the conditions would not be applicable.
Edmund Axon again. This is not a question. They're just trying to kind of share Commissioner Kura's concern, and also my concern that I don't really believe that nobody made money on this property, and as you know, every time the property changes hand, somebody makes money. And that's the nature of this development. And I'm also concerned that I think the last meeting I asked the petitioner what do they have planned for the property, and said they don't have any plans. I'm afraid that later on they come back with another proposal, and with different conditions, favorable or trying to get away from the original conditions and getting a better conditions than before. Like I said, we're gonna be watching this property. I cannot really believe that the owner of the property is just gonna let this property follow or no activity or development in the future. I just can't believe that. Thank you, Mr. Chair.
Thank you very much, Commissioner Axon. Commissioners, further questions for Mr. Hopper or Maui County? I had none, but Ed has inspired me. I want to follow up on a couple things that he said, and this might be a question for Ms. McLean. Does the county of Maui have some kind of tracking system for all the affordable units that have been promised for already entitled projects?
Chair, do I need to be sworn?
Yeah. Do you swear from the testimony you're about to give is the truth?
I do.
Okay.
Yes, the county does have both the Department of Housing and Human Concerns and the Planning Department track 201H or the county level 2.97 fast track housing approvals. Additionally, the county tracks all entitled projects, even ones that didn't go through that kind of process.
So do you have a ballpark number on how many units have been promised but not delivered right now, say on the island of Maui?
Not off the top of my head, but it wouldn't be hard to get that information if you'd like it.
That would be very interesting. And is there a process for tracking compliance related to progress and conditions, knowing that progress is being made towards, or are we surprised when we get a letter from the landowner?
excuse me, I don't know what happened to my voice.
Same thing that happened to Dan's, apparently.
I think so. Once a project is commenced, there are a number of ministerial permits that need to be obtained. And through the site work process, as well as vertical construction, various levels of county reviews, through that process, we track compliance, because often there are milestone conditions that certain things cannot happen before preliminary subdivision approval or before certificate of occupancy. So there are milestones like that through which we track progress. If a project never even begins, like Halemua, like this one, we may contact the landowner or the applicant just to say what's going on, but we don't track compliance in the same way as we do once a project has broken ground.
So do you have any sense of how many projects might be out there that are in this land that Halemua and this project occupy, this space rather?
Again, not off the top of my head, but I can readily get that for you.
I think my last question would be, I have one for Mr. Hopper too, but my last question would be, and this is maybe just for future consideration, but are there anything that the Land Use Commission could better do in its construction of conditions that would facilitate the county's tracking and enforcement? And this is, I almost said this at the beginning, this comes from, right, as volunteers, we are the subject of ritual annual beating in front of the legislature that we are the problem with the state's progress towards affordable housing. I'm kind of tired of it. I want to help. I don't think we're actually the problem. So if this is something we could do better, tell us how we can work better with the county to make sure these things actually get produced.
I sympathize with you. I have been the recipient of many public blows myself. In terms of tracking and enforcing condition compliance, the wording of the conditions can be very important.
Again, if this is just something for future consideration,
Yeah.
that's fine too.
No, I think it would be helpful for us to be more of a participant when the language is crafted, and also for the applicant to participate. Because what seems a reasonable milestone to me or to the Land Use Commission might not be so reasonable for the applicant. And just adjusting that milestone a little bit could be a significant difference. But in this case, there's nothing in the conditions that prevented this project from being built. It's external conditions, water availability, that have been the problem here.
Thank you, Ms. McLean. And I recognize Commissioner Giovanni has his hand up. I did say I had one quick question for Mr. Hopper, which is you suggested that it's possible to perhaps prevent developers from coming forward and getting entitlement in the future if they fail to comply with previous conditions. Did I hear you correctly, Mr. Hopper?
Oh, I didn't. I don't think I intended to say that. I talked about infrastructure. I think that injunctive relief could be possible in certain cases, as well as preventing. I didn't mean future entitlements and other dockets. I'm talking about if a project starts to build, and for example, they were supposed to build affordable units before market units, or they do something out of order. I think the county could say, stop building. You're not getting any more units until you do X, Y, and Z. Or if they were supposed to build a road or something before units, and there were, the road's not built or something like that, you could say you're not getting any more building permits for this project until the road's built. As far as sort of
clarification.
Yeah, as far as the same landowner. I mean, I think you do evaluate the financial capability of landowners as part of your docket. So I think if the same landowner has had has had financial issues in the past or has failed to complete projects in the past, and it's the same landowner or same developer, that's something you may consider in a docket in the future. I don't think you can necessarily bar someone from applying, but you know, that could potentially, the track record of the developer perhaps could be a consideration if part of your docket considerations are the financial capability to complete the project.
What about their counsel? Could we consider that, the track record of their counsel?
I'm an attorney, so I can't necessarily, I feel like.
You don't have to answer the question. It was rhetorical.
Yes, on that one.
Commissioner Giovanni.
Thank you, Chair. This is Commissioner Giovanni, and I don't have questions, but I do have comments to offer on this topic. I, as the chair has said, have similar feelings to those expressed by Commissioner Axon and Commissioner Okuda and the chair as well on this topic. And it's about follow through of commitments made by developers. And my comment is that in recognition of, I think over the last 48 hours, there's been a fair amount of news statewide about the Hawaii Community Assets Plan for 5,000 affordable housing units on Maui, and that plan is being submitted to Maui County government for review and consideration. Obviously, there's a great need for affordable housing on all islands, and Maui is no exception. And I was happy to see this plan being developed in a community setting and with a lot of community representation. I don't know a lot about the details of it yet, but I am looking at it. My encouragement to you, Ms. McLean and Mr. Hopper, is to take the issues you've heard about today of enforcement and delivery and on promises, and see if you could put some teeth into the whatever comes from this plan and its consideration for affordable housing. Don't ignore the opportunity to identify measures that can be put into these programs that will help assure that they'll go forward and the developers will do it. And the ideas that Mr. Hopper just articulated casually a moment ago are the types of things that might help deliver these projects to reality. And in that context, if there's anything that is recognized that the LUC can do to help the process, to help assure that these projects come to fruition, we'd like to hear about it. So thank you. That's my comment.
Thank you, Commissioner Giovanni. Further questions for Mr. Hopper at this time, or Ms. McLean? Seeing none. Office of Planning, Ms. Kato.
Allison Kato. Thank you, Chair and Commissioners. The Office of Planning and Sustainable Development has no objection to the reversion of petition area to its former agricultural district land use classification. As Mr. Hopper mentioned, we entered a stipulation with the county and petitioner, and we also submitted an amended position statement confirming our position. The Office of Planning and Sustainable Development consulted with relevant state agencies, and we found that conditions remain unfulfilled by the petitioner. In particular, we wanted to check with the State Hawaii Housing Finance and Development Corporation to see if they had any interest in working on an arrangement with the petitioner to take over the project. But they indicated in an email, which we've included as Exhibit 1B, that they and the County of Maui are not interested in taking over the project. As such, we have no objection to the reversion.
Thank you.
That's all. Thank you.
Commissioners, questions for the Office of Planning? Commissioner Axon.
Thank you, Mr. Chair. Good morning, Ms. Kato, Edmund Axon. One quick question. What happens if this commission not able to get a a vote to revert the property to its current regional designation. Let us say we didn't, the vote wasn't there. So what happened?
If you vote to not revert it,
Yes, or couldn't get enough vote to revert it.
in that case, I'm not sure that the situation would change from what it is now. I mean, the petitioner has already stated that they do not intend to fulfill any of the requirements or to go forward with this project. I'm not sure in that case what would happen. I think it would just remain as is, but I'm not sure again.
Anything further, Commissioner Axon?
No, I'm just contemplating what's the best way to do it, executive session or not.
Commissioner Giovanni.
This is Giovanni. Commissioner Axon raises a very interesting question in my mind. And would it be possible, Chair, for me to, or for us to address that question back to the county in the context of my understanding of the county's position is that they are not considering alternative enforcement actions because the preference is for reversion. But if the LUC does not approve reversion, I'd be curious as to what alternative enforcement actions the county would be considering.
Okay, so the way the procedure was laid out for today, we were going to hear from all three parties, questions for all three parties, and then any questions for any of the parties. So let me just make sure there's no questions at this time specific to OP, and then I'll allow you to ask that question to the county.
Thank you, Chair.
Anything more for Ms. Kato at this time? Mr. Funakoshi or Ms. Maki? Seeing none. Questions for any of the parties, Mr. Giovanni?
Thank you, Chair. So let me offer the opportunity to Commissioner Axon, since it was his question in the first place, to whether or not he'd like to ask that to the county or he wanted me to do it.
Yeah, go ahead, Commissioner Giovanni.
Thank you. So Mr. Hopper, this is Giovanni again. Mr. Hopper, in your response to some questions put forth, I think your words were that in recognition that the developer has expressed that it's not going to go forward, when you were asked about what enforcement actions the county could take, I think you said in general that reversion seemed to be the preference. But in the event that this commission does not approve reversion or doesn't have the votes to approve reversion, what alternative means for enforcement is the county considering?
Yes, Chair, I think I did outline under the law some of the possible options. Director McLean's here. I don't want to.
Ms. McLean's hand is raised.
So yes, if she would like to answer that, I think that that she could, if you're okay with that.
Certainly.
That'd be great, Ms. McLean.
Thank you, Chair. Thank you, Commissioner. It would leave the property somewhat in limbo because it would have certain entitlements that would dictate what uses are allowed on that property, as opposed to a reversion to agriculture, which would mean that agricultural activities could be conducted. I do not see the county taking any kind of aggressive enforcement if the reversion isn't approved today. I did work for some time in the private sector with a real estate development company. And there is, and I know I don't need to tell the commission this, but what goes into the development process to go through the effort to get the entitlements that this property obtained says to me that the applicant was not going into this project in a lighthearted way. They fully intended to develop it. But then the realities of what that development would mean in terms of the practical reality of providing infrastructure to the project, the cost of financing, the cost of developing, that reality must have hit very hard. You don't go through an entitlement process like this, even if it's just at the county level, without fully intending to develop the project. I would imagine a significant amount of money was lost in obtaining those entitlements and then really being able to do nothing with the land. So for the county to then go after the applicant or the property owner for failure to perform, it just is not the philosophy of the county government at this time. But it would leave the property with, like I said, in limbo with limited opportunities for any sort of use.
Thank you.
Commissioner Axon.
Because that's basically that's really my main point, that the owner cannot just say they don't intend to do anything on this property. I'm like what you're saying, they cannot just leave it in limbo. But the petitioner is not very open with us on what they intend to do with a property in the future. Yeah, development is always a risk. As you go into this, you know that there's a risk involved. So I understand that.
I guess a further question from Ms. McLean from me. Say tomorrow, today they have no plans for the future of the property. Tomorrow they come in with a 14.99 acre request for a portion of the property to go into the urban district. How do you consider this docket, if at all, in the consideration of that request? Ms. McLean or Mr. Hopper?
Yeah, that's a great question. Just as background, I have had extensive discussions with Mr. Oradenker about these 14.99 acre applications that we get, and we are endeavoring to curtail those and have realistic boundaries to truly determine whether something should be considered at the county level or come to this commission. But putting that aside for a moment, we would want to see much more information about viability to develop the project. I didn't go so far back into when this original boundary amendment was approved to see what the applicant had represented in terms of their ability to perform. But if something new came in, we would certainly want to see a lot of that up front so that we wouldn't go through this process a second time.
But there's nothing that would allow you really to reference this earlier docket. The petitioner's counsel would probably strenuously object and just say, listen, that's no longer at all part of this property at all.
Well, we would have to prepare a staff report to the Maui Planning Commission, and the matter would go to the county council. And in that staff report, we would give a background history of the project. Mr. Ryoka often objects to things that I say and do, doesn't keep me from doing them. Because I think that's, it's legitimate context in this case. If we didn't make any reference to it, the Planning Commission would say, hey, wasn't this that Kula Ridge project? And, we wouldn't be doing our jobs if we went, oh yeah, but we didn't include that in the staff report. One thing that can be done, I was thinking about a prior question. Generally, generous timelines you're given for when construction has to complete, has to be initiated. And there are reasons for those, but perhaps some thought can be given as to how those might be worded, or maybe to elaborate on them more so that not just this commission, but the county as well could have an indication early on as to whether something is really going to move forward. That might be informative. It might just give us more of a status rather than something sitting and languishing for such a long time.
Thank you. Anything further, commissioners, for any of the parties? Commissioner Axon.
I must apologize, Mr. Chair. I'm trying to avoid it, but I'm really kind of concerned. So I would like to move for executive session to consult with our legal counsel on the commissioner's duties and responsibilities.
Related to a failure to revert. Sorry,
What-
you're muted.
What the ramifications?
Okay. Is there a second? Commissioner Cabral?
In support of my fellow commissioner, Axon, I will second his motion.
Okay, we have a motion to go into executive session. If we do so, this meeting room will stay open. The commissioners will go into a separate Zoom meeting room for executive session, and then come out when we're done back to this meeting room. Mr. Ordenker, please poll the commission. Or sorry, is there discussion? Is there discussion on the motion? Seeing none, Mr. Ordenker, please poll the commission.
Motion is to go into executive session. Commissioner Axon,
Aye.
Commissioner Giovanni,
Aye.
Commissioner Cabral,
Yes.
Commissioner Okuda,
Yes.
Commissioner Wong,
Aye.
Chair Schreier.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
I apologize to the parties for botching it by saying this would be quick. I think that's the legal term. So we're going to go into executive session. The commissioners will be leaving the Zoom meeting room and use the Zoom meeting link previously provided by Mr. Derrickson. Okay, we need Commissioner Okuda, Cabral, OP, and Giovanni. Hi, Commissioner Giovanni. Is Kato, is that a Pokemon? What is that yellow shape behind you on your desk?
It's a bookend. It's happy.
It is very happy. I've enjoyed watching it during the course of the hearing. Okay, we're ready to go. It's 10:32 a.m. We're back on the record. Where we were procedurally is we were any final questions for the commissioners, for the parties before entering into formal deliberation. Is there any more questions for the parties from the commissioners? Commissioners? I'll ask one more time for the record, Mr. Uyoka, what are your client's plans for this property after it is reverted?
Thank you, Chair. Jeff Uyoka. Thank you, Chair. My understanding is per the earlier meeting that we had when Commissioner Axon asked Mr. Welch and what their motivation was to get the property, just to clear a couple of things up. They owned the property originally. They sold it to Kula Ridge with some seller financing. Kula Ridge did not perform. So to protect their interest, they had to foreclose on the property and they got the property back. This family trust has been in existence. Well, I shouldn't say the family trust, but it's a longtime Maui family that has the property. So to protect their interest, they had to foreclose on the property and they took the property back. And I'm not sure. I don't know if they have any real plans. Per Mr. Welch, I believe he stated they would probably sell the property again. I'm not sure what their plans on development. I don't think they're the family trust. They're not developers. I don't believe they would develop it themselves at all. So that's my understanding of the situation. Thank you, Chair.
Thank you. Anything further, commissioners, before we enter into deliberations? Seeing none, the commission will now enter into formal deliberations on whether to grant or deny the order to show cause. I will note for the parties and the public that during the commission's deliberations, I will not entertain any additional input from the parties or the public unless those individuals or entities are specifically requested to do so by me as the chair. If called upon, I would ask that any comments be limited to the question at hand. Commissioners, let me confirm with each of you that you have reviewed the record and are prepared to deliberate on the subject docket. After I call your name, would you please signify with either an aye or a nay that you are prepared to deliberate on this matter? Commissioner Axon.
Aye.
Commissioner Cabral.
Yes.
Commissioner Giovanni.
Aye.
Commissioner Okuda.
Yes. Commissioner
Wong.
Aye.
The chair is also prepared to deliberate on this matter. Commissioners, I will entertain a motion that the LUC either grants or denies the order to show cause before us. The motion should state the reasons for acceptance or non-acceptance of the petition and the conditions that will apply. Commissioners, what is your pleasure? I note the absence of a Maui commissioner who we often defer to on island matters. Commissioner Wong.
Chair, I move that we approve the order to revert this property, and that we release any of all the conditions by the decision order that was prior on this property, and that I would like to also authorize LUC to make any changes on non-substantive like formatting, modification to ensure consistency, and authorize the chair to sign the order on behalf of the commission.
Okay, Commissioner Cabral.
I will second Commissioner Arnold on that motion.
Okay, Commissioner Wong, would you speak to your motion?
Yeah, Chair. To me, this is a pretty easy one because everyone agreed, even the landowner, to revert this property back to its original designation of ag. So, and we also had a public testifier agreeing on this. So I feel that it's in the best interest of the Maui to revert it back.
Commissioner Cabral, do you wish to speak to the motion?
Yes, I'm going to agree with this motion in the fact that all parties are agreeable to it, and yet it's with great hesitation that we withdraw the potential of having more housing units in a state and on an island that is desperately in need of more housing in all economic levels, both affordable workforce as well as profitable housing. So it's with reluctance, but the fact that there's not a good basis to deny it are the funds available, I'm agreeable. Thank you.
Commissioners, we have a motion before us. Commissioner Axon.
Mr. Chair, I just want to confirm that 6 votes are needed to pass this motion.
Confirmed, because this is related to a district boundary amendment. We need 6 affirmative votes for this motion to succeed.
Very unfortunate that we only have 6 in attendance today. But anyway, I think we had a really good discussions on the issues that face the commission. As you know, developers, property owners come to us and promise all these good things, jobs for Hawaii, housing, affordable housing, but yet when they don't deliver, Land Use Commission is being blamed by all this lack of housing, lack of development, and yet we only have one option, one tool in our belt to do it. That is to revert the property back to its original designations. Everything, all the tools, all the enforcement powers was left to the counties. And even, I don't really blame the counties fully because yet they also have lacking some tools. So I'm just kind of frustrated that, things like this happens and yet, our hands are tied. Like was said, we ask the powers to be session by session that, give us more tools to do our job, but yet we're being denied. And at the end of the day, we also take all the blames. So I'm just kind of frustrated. I'm not, I just want to kind of have these discussions publicly so people understand our predicament.
Thank you, Commissioner Axon. Commissioners, we are in deliberation with a motion before us to accept. Commissioner Okuda.
Thank you, Mr. Chair. As I join in the concerns that were raised by all my commissioners during this hearing, a lot of these concerns are broader policy concerns, which are broader than perhaps this specific petition. I think we all recognize and agree that if a project is not going to pencil out profit-wise or economically, the best ideas are just not going to come to fruition. The best project designed on paper is not going to take place if it cannot make money. So I believe all of us who have any say in government would like to try to expedite and help move forward projects which really serve the public interest in ways which would help minimize the risk to developers to actually get housing on the ground so that Hawaii's people can occupy that housing. At the same time, you can see from what the commission has been doing in other cases, we will, however, carefully scrutinize the financial statements of applicants who come before the commission to be sure that there really is substance behind the representations and the promises. Because as the Hawaii Supreme Court admonished in the D.W. Ainalea case, which citations I gave before, one of the real problems or harms that occur to the community is where boundary amendments or rezonings are given, and where a landowner gets the benefit of urbanization and nothing is done except potential speculation. I do recognize that in the present case, it's the original landowner that took back the property in a deed in lieu of foreclosure, and that is a factor. I will vote in favor of this motion because under the facts and circumstances of the case, this is probably the best approach. I really hope that going forward, that if there's a further petition to change this boundary amendment from agriculture to something else, there would be that type of very careful review and scrutiny given to that type of application. And if there's an attempt to circumvent the role of the State Land Use Commission by a future applicant bringing in a petition for less than 15 acres so that by statute it does not have to come before the Land Use Commission, I urge the county, not only of Maui, but all the various counties to carefully and strictly scrutinize representations that are being made. I believe that it is our duty, both under the public trust doctrine and our duty towards the citizens of the state of Hawaii, that we carefully review and require all applicants who seek a financial benefit from what we do in government, that they live up to their promises and they actually have the financial capability to do so. So for those reasons, I'll be supporting the motion. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Commissioner Giovanni.
Thank you, Chair. Yeah, I share the feelings expressed by my other commissioners, in particular, the frustrations of Commissioner Axon. I also totally agree with the expressions of concern from Commissioner Okuda and his suggestions of the diligence that this commission must apply on a going forward basis. In that context, I know Commissioner Chang is not with us today, but I hear her voice in my mind echoing performance bond. So I just want to get that on the record. In this instant petition that's before us, I don't think we have much choice except for reversion, and I will be supporting the motion. Thank you.
Thank you, Commissioner Giovanni. Commissioners, is there further discussion or deliberation on the matter before us? I will also support the motion, really joining in all the comments of my fellow commissioners. I've appreciated the discussion. I found it valuable. I think in this particular case, there's not much we can do. Find the testimony from Ms. Naomi Hall compelling in terms of the some concerns with the project as it was laid out itself. The fact that all the parties are agreeing to the reversion. One thing I will leave this discussion with is that not just for Maui County, who now has said on the record that they actually could easily compile the list of promised units. But I would love to hear from all the counties when they comment on our dockets proposing housing from now on, like, well, how much is on the book right now? How much has been promised and not yet delivered? That would give us great value in our deliberations for knowing whether what is being asked for is needed or what is really needed is for people to deliver on promises already made. Is there anything further? If not, Mr. Ordenker, will you please poll the commission?
Thank you, Mr. Chair. The motion is to approve the request to revert the property and release all conditions, as well as authorizing the chair to sign the order and staff to make not substantive changes to the order. Commissioner Wong.
Aye.
Commissioner Cabral.
Yes.
Commissioner Axon.
Yes.
Commissioner Giovanni.
Aye.
Commissioner Okuda.
Yes. Chair
Schreier.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 6 votes.
Thank you. Mr. Uyoka, if Mr. Welch had the gumption to tell you that this wasn't a cakewalk, you can make him buy you lunch.
Thank you, Chair. I will.
Okay. Thank you very much to all the parties in this matter. Our final agenda item before adjournment is an executive session pursuant to HRS 92-5A2 to consider personnel matters where the consideration of matters affecting privacy will be involved. The LUC staff has informed me that no written testimony was received regarding this executive session. Is that still correct, Mr. Hakoda?
That is correct, Mr. Chair.
Okay, the chair will entertain a motion for executive session. And I will note for any members who are attending any parties or people attending the docket, we will come back into regular session to adjourn, but that's all we're going to do. So don't feel compelled to stick around to make sure that we're going to do that. I can assure you that's what we're going to do after we come out of executive session. Is there a motion to go into executive session? So moved by Commissioner Cabral. Second? seconded by Commissioner Wong. All commissioners in favor, say aye and raise your hand. Aye. Are any commissioners opposed? Okay, the commissioners will go into executive session, same virtual meeting room. This room will remain open. We will briefly show up to adjourn the hearing after our executive session to consider personnel matters. Thank you to everyone.
Thank you, Chair. Thank you,
Thank
members.
you, Chair.
Thank you.
Members.
Commissioner Giovanni, we're restarting. We have our Attorney General. Commissioner Wong, are you there?
I'm here.
Okay. Is there staff here or they're still gone?
They're all gone, so I'll
Okay,
just do it.
there being no further business, I declare this meeting adjourned.
Thank you. See you all. Take care.
Thank you all.